Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking at a book from Informa. It's very much their stable of publications, which are a great help in maritime law in particular. This book's actually about arbitration. There's the front of it there. You can see the title is Rules of Evidence in International Arbitration, an annotated guide. It's now in the 3rd edition and is written by Nathan O'Malley. That's the side of it, and you can see the title is actually the Lloyd's Commercial Law Library from Informa. It's a very good book. It's very, very detailed. One thing I would point out is that sometimes the actual footnotes are incredibly detailed themselves, but you've got useful paragraph numbering at the sides to find things quickly. It's under 400 pages long, and there's a detailed index which I found very helpful. We've written a review of it, which you'll find on the main sites. That's the main appendix that goes with it, which sets out the basic IBA rules as they stand at the moment. At the front you've got a standard table of cases and so forth, and you've also got something very, very useful, which is the abbreviations and acronyms. I'm very pleased with this book. Mr. O'Malley has done an excellent job in trying to put in perspective where we are in terms of arbitration work. We've given it the title Expert Guidance for Today's Practitioners and Arbitrators, basically in the arbitration field. And this is what we say in short term, that there's a much more detailed appreciation on the web. We say, by its very nature, dispute resolution is always contentious, the disputes in question being quite frequently intractable. Evidence is therefore always of concern, especially, as is usual, where there is a virtually insoluble dispute over the basic facts, in which case evidence becomes the key factor which will enable those sitting in judgment on a tribunal to come to a decision. I'm aware of how valuable this is because I've actually taught this subject to the Institute of Arbitrators in the past, and I'm well aware of some of the problems that the students have had in understanding basic rules of civil evidence in particular. The author says in international arbitration it's no different, basically, and that is that we have to come to a decision, but we've got to weigh up the evidential issues. The book's intended to provide necessary and helpful guidance on international arbitration to arbitrators, as well as clients and their representatives. So this book, published recently again by Informa in the 3rd edition, presents a proper discussion of evidence in international arbitration, which, as His Honour Humphrey Lloyd, Queen's Counsel, observes in the Foreword, is long overdue. It's also pointed out here that O'Malley has structured the book around the 2010 edition of the International Bar Association's rules on the taking of evidence in international arbitration. The IBA rules being described as a synthesis of good practice, and that's what it is. The primary source material for the book is collectively here published and unpublished as a result of case law he's found from international tribunals, and I think that's to be welcomed. I'd very much like to say that this is a book that I think everybody should have in their library if they're dealing with arbitration matters. So if you're in any way involved with international arbitration, whether you're an arbitrator, lawyer, or possibly a client, I think it's a book that you should acquire and you should certainly know and read. So thank you to O'Malley, and thank you also to Informa for an excellent contribution to the new Lloyd's Commercial Law Library series. Thank you. Bye-bye.